Hi, Bruce. See you up there.
Hi, David. How you doing?
I'm good. It seems we're doing Zoom calls every day, aren't we?
Exactly. It's a pleasure. First thing, let's start the early ones.
I can't see anyone else in the waiting room just yet, but I will admit them. So let's get going. I'll just share my screen. Great, so thank you everyone. I have put everyone on mute, but please feel free at the end to unmute. If you have any questions, please put them in the chat box and we may have time to answer them at the end. If we don't, we will take a note and come back to you if you do have any questions. Now I'd like to hand over to David Salomon, a corporate partner and a leading hospitality partner at Gunnar Cook, to introduce the session.
Thank you very much, Helen. Like many of us in the UK, I'm excited that we've started to move out of lockdown and back to some kind of normality, although I have no idea whether it's an old normality, a new normality, or some hybrid beast in between. But today, it's my great pleasure to introduce you to our webinar entitled Landlord and Tenant, From Surviving to Thriving. I believe it will contain what's written on the box and help provide a very practical and constructive guide to landlords, but particularly to operating tenants, on positive actions to take in this unusual and challenging time. So, we're very lucky to have two experts in our firm to talk to you about this very important sector. Jen Morris is a property litigation partner, which means she deals with everything that goes wrong in relation to commercial property. Those are Jen's words, not mine. She specialised in this area for nearly 20 years and is recognised as a leading practitioner. Jen is also a part-time judge, and her private practice is focused mainly on fixing problems as they arise, with pragmatic solutions rather than letting things escalate as they want to do. Catherine Payne is senior legal counsel and specialised in the commercial side of retail and hospitality leasehold property, advising operators when taking on new premises and renegotiating existing deals, which has been a huge part of her business during the pandemic. Catherine's first career was the director of a literary company, a publishing company, and she brings all of her business experience to her work as a commercial property lawyer. Her main aim in life is to try and ensure that things don't end up on Jen's desk, actually. So, what are we going to talk about today? Well, you can see the topics there.
Hello.
These are the topics that we're going to talk about. And we're going to kick off with Catherine. Over to you, Catherine.
Thanks, David, for that introduction. Yes, the first topic that Jen and I are going to look at is those new areas that tenants, particularly hospitality operators, may be using to deliver services to customers. So that would be, for instance, external service hatches being put into premises, outdoor bars, weatherproof structures for customers, new internal layouts and partitioning to help with social distancing. And really on this, I just want to say, make sure those changes, if they require landlord consent, they may have been agreed informally with your landlord, but make sure they're now documented in a license to alter, so you have evidence that they're properly authorised, as this could be important, for instance, if you want to sell your lease, or if your landlord sells the building, or at rent review or lease termination. In terms of the planning relaxation, so this is where the use of public pavements and highways for customer seating has been relaxed to allow operators deemed permission, that's assumed permission, within only 5 days of making an application. But these temporary pavement licenses usually only last 1 year and currently don't extend beyond 30th of September this year. So there is talk of extending this for a further year, but we'll probably only hear anything about this later this summer. So if there isn't an extension to that, and you want to continue using those areas, you'll need to make an application to your local authority. it's a similar position in terms of the temporary changes to the Licensing Act to permit sales of alcohol off a premises where there was only permission to make sales on the premises. And also that permitted certain licensing conditions like an hours restriction to be suspended. Now that will end on the 30th of September this year. Again, we don't know if yet if there'll be an extension to that. So if you're an operator, you would probably want to apply to vary your alcohol license if this has worked well for your business. And you would want to retain this going forward for the additional income this is brought in. So in terms of alterations, depending on your rent review clause in your lease, alterations made before a landlord gives formal consent can result in an increase in rent at the next rent review. So we say on that, just make sure you document those alterations and make sure the license to alter deals with that point if necessary. This is around the possible rentalisation of those changes, of those alterations. And finally, I just want to say, check your lease to see if you need consent to actually make a planning application or a license variation in the event that you want to make any of those changes I've touched on a permanent aspect of your business at that premises. So Jen, I'm going to hand over to you now on this topic.
Yeah, there's sort of, you've said all of the nice positive things, and it's my job always to be the miserable one afterwards, isn't it?
Yeah.
There's been a lot of talk in the press about landlords' remedies and what landlords can do in particular around rent and monies that are outstanding for the last year. But it is also important just to remember that landlords also have the power to pursue tenants for breaches of the lease other than for failure to pay the rent. It's not just about rent. If you have done something to your premises or you are acting outside the powers within your lease, then a landlord can take action against you. Ultimately, they can actually end the lease, but what they have to do if they're doing that is they have to serve a notice on you, which is a 146 notice under the Law of Property Act, to say they need to state the breach and then give you a reasonable time within which to fix it if it is fixable. That means that if you get that kind of correspondence from your landlord, don't ignore it. And I'm talking to tenants here. You need to do something about it. It may be that they will write to you beforehand, and when I have my landlord hat on, because I act for both landlords and tenants, I usually ask, particularly in the current circumstances, landlords to write first before they take any kind of formal action. If you get any of that correspondence, then you need to be re-watching this video and listening to what Catherine's just said about all of the things that you might need to do. But just be aware, a lot of the chat is about rent, but if there are other breaches of the lease, then the landlord does have power and will have power, depending on what happens in the next few months, which I'll touch on later. Okay, can we just go on to the next slide, please? Which is actually just a summary of the things that Catherine's just talked through. So that's thinking about license for alterations, pavement licenses, alcohol licensing, and rentalising. So the next topic we're going to look at, if we could just move on to the next slide, the next question that we posed was, do you have excess space, the wrong space, or not enough space? And this does go back to some of the things that Catherine has talked about. Focusing again at operators, particularly in the hospitality, you've created weird and wonderful ways to make things work over the last year, and you may want to change those into permanent fixtures for you. As well as the additional in terms of works and pavement licensings that Catherine's also dealt with, you can look at the whole area that you have and see whether or not you have excess space. There are some landlords doing deals in terms of surrender of whole, so giving back to the landlord, walking away. The one thing that people don't often think about is that there is an option of surrendering part of your premises. So an area that you don't need anymore might be able to be incorporated with a landlord into other areas. However, this would have to be done by agreement with the landlord. It is not something you can just trigger as a tenant on your own. And similarly, with landlords, they don't have to accept that. Sometimes they will, if they believe that the other option is that you as a business are going to go under. And generally, the feeling out there from sensible landlords is they'd rather have somebody in paying something and keeping things going. And we'll look at some quite creative deals, and Catherine will talk about some more about that shortly. The one thing we are seeing a rise in is essentially a threat to move somewhere else by tenants. It doesn't work for all tenants. I was talking to a pub landlord last week who he asked me what his legal options were, and I said the only option is really to threaten to go somewhere else, and it obviously didn't work for him. But that is something that we're anticipating, that there's going to be an oversupply in the market, and therefore you can consider legitimately moving out, a threat to move out if your lease is coming to an end. So we're seeing these deals in terms of surrender of part as a package of part of a package deal on rent arrears. You'll be aware there was government guidance, a code of practice that was issued in the summer last year, talking about how landlords and tenants should all be friends together and fix everything magically, and set out a list of things that landlords and tenants could consider in terms of the rent that was due from last March to date. Now, there have been an awful lot of deals being done, and one of the things we're going to think about is actually what happens after that deal ends. But some of these kind of ideas about giving back space or alternating space can be put in within some of these rent arrear spaces, and that's certainly something that both Catherine and I are seeing. And the other things that landlords are looking at are things like agreeing rent reviews, extension of the lease term. We've seen quite a lot of that actually, but also removing tenant breaks. So you might say, okay, well, you can take a smaller space, but you're not having the option to end it early, because that's what a break is. There are some landlords out there who have a mind to redevelopment in the future and are actually asking to insert landlord breaks. So they might agree a deal, but are looking to insert a landlord break and possibly change the whether or not the tenant has 1954 Act protection. Now, they're words that usually make people glaze over. What that means is that a tenant has a right to a new lease at the end of the term. So following up from what Catherine's already said, any of these variations, any of these deals need to be documented for all of the reasons that Catherine have said. Whilst we've all been living in a day-to-day world for the last year, we do need to think about what's going to happen going forward. And if you're looking to sell your lease, or the landlord's looking to sell their space, the lease, then it's really important that you have these things written down in some format. There are a lot of side letters going around on exchange of correspondence rather than formal deeds. Some things have to be by deed. Some things can be by letter. But I've got a number of clients who are development clients who are purchasing property. And one of the problems that we have on a multi-let site is that we can't get in to inspect. We don't know who the tenants are in there. We don't know what's been agreed in the last year. And actually, if you've not got it written down, you're not going to get that protection going forward. So I've already mentioned breaks briefly earlier. If you have got the ability to serve a break and you want to be able to terminate your lease, then it's one area that it's not an area to skimp on legal costs. I've just had a matter come across my desk where an FD has served a break to end a lease and they got it wrong. It's really easy to get it wrong. And if you don't do it right, that means that the lease will continue for the remainder of the contractual term, however long that will be. I have had some people ask me, what if I serve a break and then try and redo a deal with the landlord and use it as a negotiating tactic? It is a tactic that you can use, but you need to be really clear what you're doing. Some breaks are conditional, some breaks are unconditional. breaks that are conditional can be really difficult to comply with, but it's also very difficult to withdraw a break notice once you've done it, once you've served it. It's slightly easier, bizarrely, if it's conditional, but there are also other implications such as SDLT, stamp duty, land tax, and also this issue of contracting in or out of the 1954 Act. So make sure you don't miss the chance if you've got the chance, and if you're trying to use it as a tactic, you just need to think around some of the areas that's there. Catherine, did you have anything you wanted to add on this part?
Yes, yeah, just a few points. Thanks, Jen. So yes, we're seeing quite a few deals coming across our desks where landlords and tenants are agreeing flexible funding of fit outs on either new leases or lease renewals, and usually it depends who's got the cash to do that and then who gives a concession on around that. So I've seen, for instance, two office
because I was thinking of coming
over
from
the
Monday.
last week where people are agreeing to fit out and getting up to 2 years rent free because they've got the cash to fit out. And, you know, like so many landlords at the moment, they don't have any cash for anything like that because they haven't had any rent for so long. So I think there's a lot of deals that wouldn't have been available a few years ago, and we probably wouldn't have thought of a few years ago that are now on the table. Just one reminder though, sometimes undertaking those type of works can have stamp duty implications. So it's worth taking advice on that if you're doing works in exchange for a long rent-free period. And if, yes, in terms of breaks, I mean, I would agree that obviously if you can, as a tenant, introduce any tenant break rights in your deal, they are hugely valuable for trading later in exchange for other benefits from your landlord, such as, you know, generous rent concessions and maybe other long-term rent reductions. You know, if you offer not to exercise that break in exchange for one of these. So they are very valuable things to have further down the line. And a lot of our clients have taken advantage of that if they've got a break, not exercising it and getting a rent concession in exchange. And then finally, just to say, when people talk about lease extensions that are being agreed with the landlords at the moment, they usually mean actually a new lease that only begins immediately after the end of their current lease, because you can't actually extend the length of an existing lease without triggering a surrender. So that delayed commencement lease is called a reversionary lease. And unfortunately, you will need to pay stamp duty on it, even if the date that the term starts is sometime ahead in the future. So sometimes we've got situations where tenants actually want to have an agreement for lease entered into, because that has the effect of postponing their stamp duty liability. Just for that reason, if you can get that agreed by the landlord, that can be helpful. So I think that was what I wanted to say on that. So if Helen, if you can move, that's brilliant. Yes, move on to the next one after that. Actually, yeah, brilliant. Do you deliver your offering? Yeah. So on this topic, we wanted to talk about some of the recent changes you may have made to sort of when and how you reach your customers. For hospitality operators last year, the relaxation of planning rules so that pubs, cafes and restaurants could operate as hot food takeaways, that was used by quite a lot of hospitality operators. This relaxation is currently expected to end in March next year. So don't forget, if you're supposed to notify your local planning department when you stop making use of that relaxation of the planning rules. And just a reminder that some leases of hospitality venues do actually prohibit the use of a premises as a takeaway. So if you want to continue that use, I definitely suggest you check your lease to make sure you're not in breach of that user prohibition. We've already touched on licensing off sales, so that's sales for consumption off the premises. Again, just make sure you're clear when those relaxations will end if you've taken advantage of it. And again, you're supposed to let your licensing officer for that area know when you stop using that relaxed license permission. Now, this is really a Jen issue I'm just going to touch on, which is neighbour complaints. But just to say that we are seeing quite a few clients encountering strong residential opposition to applications to extend outside seating and alcohol licensing. And these applications are being dealt with really slowly. I've got a particular problem with Hackney Council. They're still using a cyber attack that they suffered last summer as a justification for the incredible delays in dealing with a very straightforward application to use outside space for cafe seating. So around that, all I'd say is, if you can mitigate any negative effect of your outside eating and drinking on your neighbours by rigorously, controlling litter, noise control, table clearing, as well as perhaps offering benefits to your neighbours like discounts and maybe allowing the venue to be used for any local events, that will help your case, I think. But I think Jen will probably say more about that. So Jen, what would you like to chip in on there?
I think everything you said is essentially is completely right, and I think, I deal with things when things go wrong, but I've certainly noticed in the last year that even sensible people are not being sensible about quite reasonable things. Everybody has suffered in some way, shape, or form. And I think actually one of the things that we're asking some space to work really hard. So when we have multi-use areas with mixed leisure, retail, and apartments or those kind of things, they're also now being used as workspace.
Yeah.
So somebody who is trying to work from home is a lot less understanding of a pavement license issue than they probably would have been certainly a year and a bit ago, and potentially there'll be a lot more understanding of it in a year's time. It doesn't help you in the immediacy, but I think there's a lot of swift local action. We certainly had our local market town's got a small cobbled area last summer, June time, when the first set of relaxations came about. The local venues got together, tried to set up an outdoor shared seating area, and it was up and then down again within 48 hours because lots of people got very grumpy about it very quickly. And everything that Catherine is talking about is all quite practical advice in terms of what you can do. And the difficulty that you have here is you're facing issues on all sides. You've got issues from your landlords, you've got issues from the council, and then issues from third parties, because any kind of neighbour and noise complaints, yes, they can go to the environmental noise team at the council, but they'll also start contacting people like me to complain. And I, to be honest, have tried to talk people down or off the edge in terms of trying to maintain some understanding for operators in the current environment, because for all of those who don't want them, they've probably got sons and daughters who do want them and do want to be able to get out there. So making vast assumptions about the kind of people that are going to complain and the kind of people who aren't. But it is quite a difficult area to work your way through. So everything that Catherine said about litter care and all of those kind of things. And if somebody does start jumping up and down, giving them the time and space to jump up and down and then talking to them is actually a lot more pragmatic solution than arming yourself with lawyers, because generally when lawyers get involved on that kind of issue, it will escalate matters. So a lawyer, not voting for lawyers there. but there you go. So I think that's all we've got to say on that. Can we just move on to the next slide, which I think is a summary of what we've just said? Yeah, so nice outdoor area there. Use class and user clauses, yeah, licensing requirements and neighbour and noise complaints, all difficult things. Okay, if we can go on to the next topic then, please. Great. So we're now going to talk about managing new income streams and a vastly variable turnover. We've touched on some of this already. In essence, there has been an enormous amount of protection for retail operators, hospitality operators and tenants generally since last March. I'm going to talk about in the next section how that might unwind in due course, and it's not completely set in stone yet. But a lot of operators out there have been able to agree rent concessions. And some of the things that we've talked about are some of the things that have been agreed within those deals. But I think a lot of people that agreed early on, say in May, June last year, never thought that we would still be in this position now. And it is actually really important that to know when they're going to end. Because the work that Catherine and I both did this time last year probably dealt with 9 months, a year, that kind of thing. Catherine's nodding her head. Yeah. And a lot of them are coming up now. And a lot of them are just done in a side letter, done quite quickly. But the issues are still there. We don't know how Joe Public is going to react to opening up. We don't know what's going to happen next, particularly in relation to the amount of capacity that you can have indoor. Yes, fine, great, you can have indoor people hopefully in the next couple of weeks, but then actually the cost of that and all of those things are still, a lot of that is to be worked out, and the appetite out there. So it's important to continue as a hospitality operator and a retail operator to keep the conversation going with the landlord. Don't assume that you'll get the same deal, because there has been a switch in the mindset that I've seen from landlords, whereas last year they were happy to agree things on a short-term basis because they too believed that there was no way that we would be still in this position now. But what they don't want to do is to give tenants deals that just carry on and on and on and on, because as Catherine's pointed out, a lot of landlords haven't had any rental income for a year. It's usually those that are leveraged, those with significant lending have had concessions, but there is an awful lot of middle ground where they've had very, very little support from the government. They might have been able to furlough some staff, but very little support, and therefore that they are now looking to do that. To look to what I would call a more medium-term solution rather than a short-term solution that they agreed last year. Be really clear about things like monthly rents and quarterly rents. Don't assume that your monthly rent's going to be able to continue. You may have to find, particularly with the June quarter day coming up, and I'm hearing landlords saying, well, everything's going to be fine, it's going to be after June the 21st. They can pay the full quarter for June on June the 24th. And it's actually managing that expectation, which is really important. So payment plans as well. If you agree to defer rent, but that you'd start paying it, you're going to have to start paying it. And you need to be really clear when that starts. And if you need to renegotiate, you're going to have to go back to the landlord with additional information. A lot of landlords looked for acceleration provisions if you breach. Now, me and Catherine probably sat on slightly different sides of the fence here, because I ended up doing a lot for landlords and Catherine did a lot for tenants. And for a landlord, I was saying you've got to try and have an acceleration provision in. And what that means is if you're in breach, everything, all bets are off the table, everything's owed, they can do everything that they possibly can. And that has also been backed up with a government protection on the tenant moratorium on some of the landlord remedies, which we'll turn to next. And I'm sure Catherine was very successful in negotiating out acceleration provisions wherever she could for her tenant clients. But in reality, there are an awful lot out there that do have acceleration provisions in. So if you are in breach, then the landlord can come after you. And that, with the double whammy of potentially the government protection lifting, could be a real problem. So make sure you know what you're meant to be doing when. The other thing to talk about is turnover rents. Catherine and I had a conversation about this before last week, and I think she said management information accounts have been bandied about like confetti. That kind of, that there's been an awful lot of information that's been going from tenants to landlords in order to justify supporting them. As a tenant, speaking to tenants, you want to be able to try and unwind that, because you don't want the landlord think that they're going to have that forever. So if you are agreeing any more deal with them, that you have a very clear end of when that finishes. So whilst I'm saying be open and clear and transparent with your landlord, don't bring them to expect that that's going to happen forever, because that is actually quite a significant burden. And also, generally, once the restrictions are lifted, landlords have an awful lot of remedies and options available to them. So getting an insight on what's going on and nosing about isn't something that they necessarily need. And my notes say it'll be hard to wean landlords off, and I think that's true. But it's just understanding what they want from you and when, because it is a significant thing. A couple of more practical points. Landlords may have drawn down on rent deposits. There are usually provisions in rent deposit deeds to say you have to top it back up. A lot of landlords I know haven't asked tenants to top it back up, because the whole purpose of it was the fact that tenants didn't have any income. But certainly I think in the second half of this year, landlords will be calling on tenants to top back up their rent deposit. So don't let that be a surprise to you. So we're going back to the question of the 54 Act next. So if you have a lease which has the protection of the 1954 Act, again, speaking to tenants here, that means that you can ask for a new lease on similar terms at a market rent at the expiry of your old lease. And generally, the rule is when the market is going up, landlords trigger lease renewals and trigger the whole process. And as the market is going down, tenants trigger that. And that's by service of notice or request. Between 6 and 12 months notice, it has to expire on or after the end of your current lease. But you have to trigger it in order to get what's called interim rent. So that means the rent under any new lease will be triggered back essentially to the start of the process. So that means if you are sitting in a premises which you're happy to be in, but you want the rent to be at market rent, and we all suspect that there's going to be an oversupply of space and therefore that the rents will be going down where available, you want to be triggering that if you can. Again, that is something that's a very small discrete area of law, and it's very easy to get wrong, and it's quite easy to get the advice to make sure when you can do it and how you can do it. The reverse of that is existing lease renewals. So renewals that have been triggered either during or before the pandemic are really struggling to get anywhere, because landlords are really struggling to be able to justify agreeing newer, lower rents, because at the minute there is this cotton wool wrapped round in terms of the tenant moratorium on some of the remedies. So there hasn't been a load of, there are an awful lot of empty premises out there. I'm not saying that there aren't, but there is an expectation that there may well be more, and therefore landlords are dithering about agreeing deals, and certainly are struggling to see comparables out there in terms of rental values, because we're seeing that on rent reviews as well. That a lot are being agreed at nil, and there's just trying to muddy its way through. So if you are sitting on an existing lease loan and it's not going anywhere, my words of comfort to you are you are not alone, because not only is rent a difficulty, but also what the terms of a new lease should be in terms of what people are going to come to in terms of a standard market sort of COVID protection clause, and we'll touch on that again shortly. So managing new income streams and vastly variable turnover. So if you can just go to the next slide, which has got your thinking points. So rent concessions, what did you agree? Turnover rent and management information. I've mentioned, and also triggering lease renewals. If you have a lease inside the Act, you can trigger it. If you have a lease that doesn't have the 1954 Act protection and it's coming up to an end, you also need to start the process of negotiating terms for a new lease or new space or all of those things sooner rather than later. So Catherine, do you have anything you'd like to?
Well, you covered a lot of
Words of
ground
wisdom.
there, I think, Jen, actually. There were, a few points I think I was going to discuss. I mean, in a way, you've covered very thoroughly. So lease renewals, yeah, I totally agree with you. We're seeing those being either lease renewals or reversion releases. We're seeing the terms being renegotiated again and again, and then stalling and then renegotiating. I've had some deals that have gone on for sort of 18 months, going backwards and forwards with as the landscape changes for landlords and tenants, in terms of whether they want long leases, short leases, breaks, whether they want to redevelop or whatever. So absolutely agree on that. Yeah, rent concessions. I just to build on what you have already said on that. Some of the rent concession terms were very simple. Other landlords, usually the ones that use the bigger institutional landlords, often had very, very detailed rent concession letters that included a huge number of tenant obligations. Some of them around things like notifying them if the tenant benefits from a grant, a government-backed loan, or gets a payout on their business interruption insurance, which has been a recent topic, obviously, because there's been, for the benefit of tenants, there's been a ruling on the definition of the events that can give rise to your business interruption insurance policy paying out, which is great, but you may find you have an obligation to notify your landlord of that, because they want to then obviously get their hands on some of that money to settle their arrears. So it is really important that you really check that you're either complying with all of those, or if there's anything that you need to flag up, as Jen was saying, where you may need an extension of something like your right to pay monthly. I think that's going to be crucial for cash flow, is being able to pay monthly going forward, maybe for a year or two, if you can get it, while your cash reserves build up again. And then on turnover, yes, I mean, we're seeing, I suppose we're starting to see more deals where landlords are willing to go down a turnover route. I'd just say, be really careful about what's included in the basket of turnover that they can take a slice of, because obviously the landlord will want to put as much stuff into that basket as possible. And also there are some quite complicated turnover mechanisms where you get a sort of ratchet arrangement of a base rent and a turnover top up, which is effectively reviewed every year, so that your base rent will always be 80% of what you did the previous year of turnover and rent. And the long and short of that is it can just mean, effectively, if you're doing well, that your base rent is increasing every year instead of every fifth year. So, just be aware that some of the turnover provisions are not, tricky. And just also, if you've got a turnover rent, you'll need to look at the stamp duty provisions carefully, because you will probably need to give a reasonable estimate of your total annual rent, including turnover. And the sting in the tail is that you are required to review that after 5 years on the basis of what you've actually done, and then maybe top it up to HMRC, or apply for a refund. I'm sure they must be very slow coming through, those refunds. So yeah, I didn't really have anything else to say on that. And I think just in terms of, have we got the next slide up yet?
Yes.
Yes.
Back to me.
Well, back to you for if it all goes wrong.
I have an empty desk, and it'll end up on my desk. Okay. We've mentioned a couple of things on the way through about the tenant moratorium, and I'm sure you know a lot about it, but let's just remind ourselves. So the current protection for tenants expires on the 30th of June. 2021, and it basically stops the landlords doing all of the things that they normally do, except suing you for rent arrears. And again, I am delivering this to tenants, so apologies for landlords that are on here, but it's useful for you as well. But I'm going to talk about tenant protection, so I'm going to talk to tenants. So the powers of a landlord are changing the locks, posh word for that's forfeiture, appointing bailiffs to come in and take goods to the value. That's now called CRAR, C-R-A-R, and there are now notification procedures, but I still like to call it bailiffs. And then also starting insolvency proceedings, which is serving a statutory demand, and then winding up proceedings against a company, or bankruptcy proceedings against an individual. Essentially, they are all currently mothballed, and they are due to expire on the 30th of June. And what has happened for the last year is that sometime before the quarter day, that has been extended for another quarter. And certainly in January time, certainly prior to the December quarter day, I thought the December quarter day was going to be the last before we then had the mass issues that we had in December and January. Once that happened, it was then clear that there was going to roll over again on the March quarter day, so there wasn't much. But the June quarter day also coincides with Boris's vision of releasing us all, and we don't know what that's going to be at the end of June. What the government put in place was this code of practice, which I've already mentioned in slightly derogatory terms, about the fact that it doesn't really do anything other than give you a list of things to talk about. There is no teeth. There are a couple of court decisions which have come out and in the last week or so, which are very clear, that say this is just a recommendation. If the landlord hasn't complied with it, it doesn't matter. They can still sue the tenant for arrears, the one thing that's left on the table for them. And there are landlords out there who are suing, including some of my clients. And I think I'm finding certainly the landlords that are suing are very much fed up of a lack of engagement by their tenants. Because in reality, if you sue somebody and you get a judgment against them, unless they pay it, you then have to enforce it. And a lot of the enforcement options are also wrapped up in cotton wool. So actually, you get a judgment debt and you have 6 years within which you can enforce it. So it's just sitting there on the table as a massive stick against tenants. But it's also about landlords getting fed up of tenants not dealing with them. I've got a matter on for a very sensible landlord who's usually quite pragmatic, and it's against a substantial convenience store owner, and they just got fed up of them continuing to trade, continuing to get government support, but not giving any information about how well they were doing or how they weren't doing. And if they provided management information to show that they weren't taking as much trade, then the landlord, I'm sure, would have given them a deal, but they just stuck their head in the sand. So the landlord, my client's now suing them, and they know that once they've got the judgment, they're going to have to sit on it for a while, but they've got it. And it's a clear indicator to the tenant that there's no chance that they're going to get a deal on the arrears that have accrued over the last year. So these powers are all limited. We then currently have the cut-off date of the 30th of June. The government issued a consultation a couple of weeks ago about what will happen next, and they took a call from evidence from the whole sector. You may well have seen something about it. Some of the associations that I'm in also contributed to it, not me directly, although I have been through the questionnaire online myself, just because it asks about who's been complying with the code, what kind of deals have been out there, and then it gives a sort of menu of the 6 options that they're considering. The first one is just that the current protection expires on the 30th of June, and then that's it. It's complete drop dead. Anybody who owes rent will then be able have all of those possible things thrown at them by the landlord. The second option is that the forfeiture moratorium ends, so the landlord can go in and change the locks, but what they can't do is appoint bailiffs to come in and take your trading stock or your trading equipment, and they also can't make you insolvent. And remember, if the landlord forfeits, there is an ability for tenants to apply for relief from forfeiture, which is an equitable remedy. Equitable is a lawyer's way of saying it's fair and you're asking the court often on payment of some or all of the arrears to be able to give you the property back, and you would anticipate the court may give more credence to tenants that have engaged in a process and engaged with the code than not. But we shall have to wait and see, because the current cases that have come out in the last couple of weeks, and they are all about tenants saying the landlords haven't complied with the code and they shouldn't be allowed to sue, have been very landlord friendly and said yes, they can get on and sue. So option 1 is a complete expiry and it's a free-for-all. Option 2 is that the forfeiture moratorium ends, so landlords can change the locks, but the other things that they can do, their measures remain for some period of time, an unspecified period of time. Option 3 is to keep the existing cotton wool, but only limit it to businesses in COVID hit sectors. And the problem that they'll have there is defining COVID hit sectors. Certainly you would anticipate that hospitality and retail will be in those. There can be no doubt of that. But what I suspect that will cause them not to go down this route is the difficulty they will have in actually agreeing who's been hit and who hasn't, because of some of the other support that's been given. I was a trustee of the local nursery, a local preschool when this all started, and faced and it was a great issue because the nursery sector didn't get any support. Everything had to shut, all of those kind of things. But then they did get support in lots of other ways. They eventually got support through the local authority route rather than through the government route. And I would probably struggle with some of those people getting the support again, because they got a route by a different way. And I'm not sure that everybody really understands all of the different sectors and what support they got. So I sort of feel like option 3 is just going to end up in a bun fight. But then it is quite like this government to put something out without having necessarily thought through the definitions. So we shall wait and see. The last 3 options, I said there were 6, are all essentially the same thing, but to different degrees, and that's mediation and adjudication. So having an independent third party come along and sit and listen to the landlord and tenant. And the difference between that is whether or not they're binding or non-binding. So you can go to a third party, you can listen to what they have to say and say, I don't care. That's when it's non-binding. Or you can have it where it's binding and somebody has to come along, and whatever they say, they look at how the landlord and the tenant has been impacted, and then they decide how the arrears and the issues should be split. Whilst I'm generally a massive fan of third-party mediation or adjudication, my concern with all of those 3 options is there are just not the people out there to be able to do that. And it's just going to cause more delay and uncertainty, because what happens in the meantime? What happens if you're just going to wrap all of this and shove it in a corner and say, well, we'll sort that out later? All of the things that we've been talking about today has been talking about an ongoing relationship between landlord and tenant. And I think both landlord and tenants are going to struggle to wrap up the last year's worth of issues, hive them off, and not carry on and deal with them appropriately. And there's just not that many mediators and adjudicators out there. So we shall see. So the call for evidence ended yesterday. We should hear, I would hope, sooner than some of the other announcements. So I would hope to hear the beginning of June, but whether my hopes will be met or not, I do not know. So it is really important that you just keep up to date with what's going on. It is a nightmare to keep up to date with everything. It's a constant flurry of what's going on, what's happening, and particularly at the time when you are completely focused on delivering a COVID safe operation to your customers and getting back to doing the things that you know how to do really well and that you have enough to do. I worked in retail management for 5 years, and you are running to stand still. And so please just don't forget these things. I'm certain I will be very busy, and Catherine and I, in the run up to the quarter days for the last year, have been very busy answering quick queries, and that's not a problem. But if you can, please try and keep up to date. I think I've covered everything, all my miserable bits there.
Yeah.
I haven't gone over the powers of councils, which is the other thing to do if the tenants get it wrong. But I think we covered that earlier, and I'm conscious of time.
Yeah, exactly. I'm a bit conscious of the time on this. I mean, I hadn't got much more to say on that really, apart from obviously just be clear about what your exposure is as a tenant, as a company. You know,
Definitely.
got personal guarantees, parent company guarantees, rent deposits, expensive equipment, all that sort of thing. And also, I just wanted to check with you, Jen. And this is the last depressing point: is how quickly can landlords start taking action if they haven't agreed a deal? Is that
pretty?
After?
Yeah, pretty much straight away. There, in terms of if we end up in the drop dead situation where all protections expire on the 30th of June, there are some minor things to do with grace periods and leases, and what's happened on monthly, which I could talk about for an hour, and I won't because you'll all be asleep. But essentially, first week in July, and that is what a lot of landlord clients will be asking me about from the 1st of July.
Yeah.
Typically, I've had tenant clients asking me in the run up to the quarter day, and then landlords asking me after the quarter day. People are on this. People know that they want that once the rules are clear, they will start taking action very quickly.
Thanks, Jen. And I think probably David, I mean, we would at this point be looking at some questions. I'm just thinking time-wise, maybe.
Yeah, I mean,
maybe we should deal with the questions.
We have run over, and I had a series of questions that I was sent beforehand, pretty well all of which have actually been answered.
I
Just
think we've answered.
give a question, they're answered. There's just one I'd like really for you, Catherine, which is just, are landlords actually agreeing to COVID clauses in new leases now?
Well, my experience is very few of them are, and if they are, they tend to be modified so that if you've got a COVID clause, what we're talking about is something that gives you a rent concession in the event of another COVID pandemic or epidemic. My experience is that very few landlords are agreeing to them. If they are, it's to do with giving them a very small concession if the whole premises is shut. It's often limited to just COVID-19 in the definition, which means that if there was a COVID-22, you wouldn't be covered. And
Trump would be in trouble then, wouldn't he?
Yeah, and that usually if there's anything around that, it tends to be in a turnover rent based lease, so that you get some reduction in your obligation to pay the base rent if you're shut, or you maybe get a reduction in your sales targets if you're shut. But you know, that's most people are just in my experience resisting that strongly.
I think there was a case which was a lease renewal case a month or so ago, where the two parties agreed a 50% COVID reduction. And the court wasn't being asked to deal with that because it was essentially agreed between the parties, and it's being floated around as this is what everybody is agreeing. This is, you know, what you should be expecting. And I've had that where people come to me and say, you know, is this true? And it's like, no, actually, the parties agreed that, and the court rubber stamped it, and that's not what the case was about. The case was about something else. So also just take with a pinch of salt somebody telling you that absolutely everybody else is getting this or not, whichever side of the fence you're on.
Well, that's great. Well, I mean, Jen, Catherine, thank you so much for a wealth of information. We all learnt a lot today. I certainly did. And now I'm going to pass. No, I did really. I'm going to pass back to Helen. You there, Helen?
Yes, thank you everyone for attending. If you do have any questions, we'll be sending around a follow-up email with the contact details of the team. So please do feel free to get in contact with them. Otherwise, please drop me an email and I can direct your query. But thank you very much to everyone who's attended. Have a lovely day.
Thanks, everyone.
Thanks, everyone.
Thank you.
Take care.
Bye.
Bye.
Thank you.